Hello, everyone, and welcome to the next installment of Lexsynergy's webinar series. My name is Marina Robbins, and I am the Marketing Manager at Lexsynergy. Lexsynergy is a global domain name management and online brand protection company with offices in the UK, South Africa, Kenya, Australia, and San Diego, which is where I am based. We are pleased you're able to join us for today's call, and we hope you find this information useful. On this webinar, we'll be discussing the process of resolving a domain name dispute via outlets such as the UDRP and URS. We'll leave some time at the end of the call for questions and answers, so if you do have a question, please send those through using the Q&A function on the WebEx. I'd also like to take this time to announce that Lexsynergy will be exhibiting at the 2017 INTA annual meeting in Barcelona this coming May. And I know we have quite a few IP attorneys joining us on this webinar, so if you are attending and would like to set up a meeting, please email us or call, or you can find us in the exhibit hall at booth number B31. I would now like to introduce Daniel Greenberg, the presenter for today's webinar. Daniel is the CEO and founder of Lexsynergy. He is an admitted attorney in the UK and South Africa with over 15 years experience in trademarks, copyright, and domain names. Daniel's academic works on domain names have been published in leading IP publications. With that, I'll turn it over to Daniel to start the presentation.
Great. Thank you, Marina, and I'd like to welcome all the attendees to this webinar dealing with the UDRP. The mailer that went out mentioned the UDRP, but what I will do during this webinar is touch on a few other dispute resolution mechanisms around the world. And really what it's intended to do is kind of give you an overview of, what to look out for, how to go about dealing with a domain name dispute. It is interactive, so if you have any questions, like Marina says, if you can put them in the comment box. It may happen that during the webinar you will have a question, put that in. If I have the opportunity, I'll answer it there, and then others we can wait till the end of the webinar to address any questions you may have. A topic of this nature can be a full-day lecture, so what I'll do is my best to cram it in within the next 20 minutes or so. There are a lot of acronyms in the industry, and obviously there are there's legal terminology. So if there are any questions regarding that, please let me know. The agenda and the setup of this webinar will deal with domain name infringement terminology and acronyms. We'll go into a bit about squatting, the first steps, what you need to do when a dispute is identified. Then from there, the UDRP process, proving your case. A few UDRP cases I'll discuss and mention to you, highlighting some of the issues that can crop up from time to time. Then deal with the UDRP versus the URS, which is quite relevant, especially within the new GTLD namespace. And then CC/TLD complaints, highlighting it in certain countries, mostly focusing on English-speaking countries. And then Q&A for you guys if you have any questions at the end of it. So moving on to terminology, cyber squatting and typo squatting, you'll see in the next slide. I'll go into that in more detail. But essentially, the difference between the two is the one is cyber squatting is where a person takes an identical mark and registers that as a domain name. So if it's Google, they register google.business, or they incorporate that mark with other words, so Google domains.business. Typo squatting is where a person uses the misspelling of the domain name. So this could happen on the QWERTY keyboard or QWERTY or AZERTY, depending where you come from, where there are common misspellings and typos, and as a result, squatters use that to maximize their profits by directing unsuspecting users to a certain website. There's reverse domain name hijacking. This is where a trademark owner, funny enough, tries via a domain name complaint to gain control of a domain name to deprive the owner of that. So in essence, it's a trademark owner trying to bully a person that maybe has a prior right to the domain name to try and get that transferred over. We actually had a client that had a domain name, it's Visual Voice, and he had this domain name for several years. And then what happened during the holiday period, I think it was around June, July last year, someone filed a UDRP complaint trying to gain the recovery of that domain because they filed a later trademark, and we were successful in defending it on the grounds that he had made intermittent use of it, and his domain name predated the trademark registration. It also highlights the fact with the UDRP, as you'll see in later slides, you have 20 days to respond to a complaint. So sometimes you'll find a complaint is submitted over the Christmas period or the summer holidays, depending where you are in the world, so that the person may not be able to respond within the 20 days, and as a result, it could go to a default judgment, which is not ideal. Then going into the other terms is the UDRP, the Uniform Dispute Resolution Policy. We'll get into that in detail. What that is basically when you register a domain name, in your registration agreement, you agree to be bound by this UDRP, and it deals with the procedures and rules involved in a domain name dispute. All the new GTLDs use the UDRP, or when a person registers a domain name, they agree to that, as well as the traditional GTLDs such as COM, NET, and ORG. And then some CCTLDs have signed up to the UDRP in various forms of it, so it's a very similar procedure to that. The URS is the Uniform Rapid Suspension Policy or System, and this is where you can suspend a domain name. We'll get into that later on as well. Supplemental rules, it's important to remember there are a few providers that hear domain name disputes or, under the UDRP, and each of them have their own set of rules. So it's important to look at those set of rules and see which one best fits your situation or your client. I will talk about the provider that we use as well as the others that are out there. I do list some of them down there in the blue. You can see there's WIPO, the World Intellectual Property Organization, the National Arbitration Forum, that's the one we use, the Czech Arbitration Court, that's quite a recent one, and then the Asian Domain Name Dispute Resolution Center. Jumping up a little bit to the ADR, that's the Alternative Dispute Resolution. There's certain countries that have a different approach to, or different set of rules to domain name disputes. So that would fall within .eu and .co.za for South Africa. They branded under an ADR. Then you get a dispute resolution service, which is dealt with by, or Nominet uses that particular dispute resolution procedure. So looking at that, we normally favor the National Arbitration Forum, and you'll see why a little bit later, but there is a cost implication. The WIPO charges $1,500 to file a domain name complaint, while the National Arbitration Forum charges $1,300. Although it's only $200 cheaper, sometimes we find that the decisions are more consistent. I know some lawyers do disagree with me there, but that's just our personal experience. And the supplemental rules do, under the National Arbitration Forum, allow for a type of reply if a response is received. Although one advantage of WIPO is that you do get a refund or a partial refund in the event of a settlement or a withdrawal of the complaint. So that's something to also look at. So just moving into the squatting, just so you have an idea of what it looks like. This is a relatively old example that I've used, and old in the domain name space, which is a couple of months. So as you can see, hsbc.xyz, someone's registered that. You can see the registrant organization is a person based in China. I won't pretend to pronounce that name, but it's someone in China, clearly not HSBC. HSBC, as you will know, is a bank in the UK and throughout Europe, or an international bank. So .xyz had a promotion where they offered free registrations. Obviously, someone took the opportunity to register that. So now this domain name exists. When I did check the domain name at one stage, I went to the website. A pop-up came up where it said I was a certified winner, and that form that you can see over there said, click on claim now, and it took me to some sort of fraudulent site. It is dynamic, so it does change from time to time. I would ask that you exercise caution if you do want to visit that site, just in case there is a virus or some other thing on that website. Then you look at the type of squatting example, which is HSBD. And if you have a QWERTY keyboard like mine, you'll see that the C and the D are quite close together. And co.uk, HSBC is a big bank in the UK. It's easy to make a typo. So this person's registered this domain name, and a lot of traffic is directed to that particular site. So it's in the interest, and I'm surprised that this particular bank hasn't taken action to recover these domain names. If they're your client, there's potential work for you there. So that's squatting, just an example so you can see what we faced with. Now the first step, so what happens is your client approaches you, or it happens to your business that there's a domain name dispute that is identified. So you need to look at, is the domain name registered in a ccTLD or gTLD? The reason we say that is there are different procedures for the recovery of domain names depending which TLD they come from. So a ccTLD, which was actually on the definitions page, is a country code top-level domain. That is a .uk, .za, .us, .de for Germany, and a gTLD is a generic top-level domain. That's a domain name that's not assigned to a specific country. So it is .com, .business, and all those new gTLDs that have come out. So it's more of a kind of an internationalized, international domain name, should I say. So once you know what it is, you then know the different rules. If it's a gTLD, then the UDRP is an option, URS. In some cases, if it's a ccTLD in, say, in Germany.de or Austria.at, the local courts would then be an option. It's not every country has a dispute resolution service. Then another important thing to look at is the registration date. There are two parts of that registration date. The first is to see when the domain name was registered. Does it predate the trademark registration? If it does, there may be an issue there. If the registrant has prior rights, it may be difficult to prove that the domain name was registered and used in bad faith. If it was post the registration of a trademark, then it's obviously easier. Another thing to look at is on the registration date is that if the domain name is coming up to the expiry date, say you're in April and the domain name ends at the end of April or the registration period ends, we'd say don't file a complaint yet, put it on a back order, snap-up service, so hopefully the domain name will not be renewed, and then you could potentially snap that up without having to go through a recovery process. Then assessing client's rights, which links to the registration date. There are some exceptions to that where clients haven't secured their trademark so that a person does register the domain name before the mark is filed. This can occur where there's an announcement, a merger, or someone entering a new market. It's happened to some of our clients where, for instance, someone has insider knowledge that one company is going to acquire another. So what a squatter would then do is take the two company names, put them together, register the domain name, or try and anticipate what the name will be, and then through that register a domain name that they could potentially squat on. So in those cases, there are exceptions to say that it was announced prior to the trademark being filed. It's also good advice to give your clients or internally to make a decision not to announce certain marks before you've actually gone through the process of filing a trademark. I know sometimes the world of the business doesn't really fit in line with the way trademarks work, but it's good to seek early protection if you can. Another thing to look at is the language of the particular complaint. The way the UDRP works is if a domain name was registered and the agreement was in a certain language, that's the language that the complaint needs to be filed in. So if the squatter registered the domain name with a Chinese registrar, the agreement would obviously be in Chinese. That means your complaint must be filed in Chinese. There is the option of a language argument within the UDRP where you can argue that the language should be English or whatever language you use. The reason for that is you don't want to frustrate the process or the UDRP by having to go and translate the complaint. It could delay the whole process. So there is a whole argument that you can put in there to try and get it heard in your language. Then it's a proxy and privacy service that you need to look at. A lot of squatters do use these services. What they do is they conceal their true identity. So instead of putting their information on the Who Is record, which we saw in the previous slide, they use that of a third-party provider. They pay an additional fee, and when they pay that additional fee, they then conceal their information. So it's worthwhile seeing whether that can be removed prior to filing the complaint. The reason for that is it may be an employee that's registered the domain name and has used a proxy service, so you don't know who it is. It helps with investigation to know who the party is. If you cannot remove the privacy service, you do have the opportunity to amend the complaint once it is removed after filing. Another thing that you should look at is the pattern of conduct, and that is, has the particular squatter, do they have previous decisions against them? Do they own any other domain names that infringe upon well-known rights or other trademark owners' rights? Because that assists in proving bad faith. So these are some pointers when a domain name dispute does arise for you to look at. The next is the UDRP process. I apologize for all the arrows going back and forth. I try to put this together to kind of best explain it. It does differ from provider to provider, and depending if you go through an ADR in a different country, the process is kind of similar with a few variations to it. So looking at the UDRP process, it starts off with the complaint. So what you do is you prepare the complaint, you then file it with a provider, so we choose the National Arbitration Forum. They then send the complaint to the registrar, who then has to verify the information. The registrar then, once they've verified the information, locks the domain. That means that the owner cannot transfer the domain name away or cannot update the domain. What happens at that stage, if it's using a privacy service, they either, if it's their own privacy service, remove the privacy service to reflect the new owner or the person behind the privacy service. So when that happens, the provider will then come back to you and say, well, you need now to amend your complaint because there's a different registrant. So that's when it goes back to the complaint process. You have normally about 5 days to amend the complaint. You then amend the complaint, then the provider serves it on or sends it through to the respondent. The respondent then usually has around about 20 days to respond to the complaint. If there is no response, it goes to the arbitrator or panelist for a decision. With the National Arbitration Forum, and one of the reasons I use it, is that there is an option by paying an additional fee that you can have an additional submission or written statement. It's technically not a reply. What it is the respondent could have introduced a new set of facts that you weren't aware of at the time that the complaint was prepared, so it allows you to address that. What it does not allow you to do is to amend your original complaint. So it's really answering some of the or aspects of the response that you may not have been aware of at that time. I'm not too sure if WIPO has an option for that. I know the National Arbitration Forum does. We've only done it or submitted a reply, I think, on 2 occasions. So it doesn't happen too often. Then once it goes to a panelist, one of 3 things can happen. The domain name can be transferred. The domain name can be canceled. Cancel means that the domain name is deleted. But the problem then arises that anyone else can snap it up and then you're in the same position. So the default request is transfer. And the third option is if you're unsuccessful, there's no action. That the panelist will doesn't decide in the complainant's favor and the domain name remains with the original registrant. Just going back, sorry, and the whole process can take plus minus 60 days from submitting the complaint to receiving a decision, and then the registrar is compelled under the UDRP to transfer the domain name over. So there's no risk that you won't get the domain name. And if the registrar doesn't cooperate, there are procedures within ICANN to report them in order for them to comply. One other thing to remember, in a decision, you cannot claim damages or costs or anything like that. And that's why there's a lot of squatting in that there's no financial obligation on the respondent. The only financial obligation would be is if you've selected one panelist instead of three, because that's the option. If they want three panelists to hear this decision, they would then have to pay an additional fee. So otherwise, they simply don't respond if it's a well-known squat. In some cases, they do. Majority don't respond. So most of you may be familiar with this process, but in the UDRP, in order to succeed, you basically have to prove three things. The one is that the respondent's domain name is identical or confusingly similar to a trademark in which a complainant has rights. The respondent has no legitimate rights or legitimate interests in the domain, and that it has been registered and used in bad faith. And that "and" is very important. In some variations of the UDRP, in some CCTLDs, they use the word "or," but here it's "and," so it needs to be used, and I'll discuss that when we get to this element in more detail. But going back to the first element, you need a trademark. It's sufficient to have a common law trademark, so that is an unregistered trademark, to file a UDRP, but then you would obviously need a lot of evidence to establish a reputation and that you're relatively well known in your industry and that anyone that sees your mark identifies it with your type of business. At this stage, it's also important, as I've previously mentioned, to look and see when the trademark was first registered and applied for, or if it's a common law mark, when it was first used, as those dates are very important. In addition, you need to submit substantial amounts of evidence. I tend to go a bit overboard, even if my client has registered rights, but that is because you don't know who the panelist is and you don't know what they may be asking for. And because it's based on an application proceeding and there's no hearing or face-to-face arguments, you need to kind of put everything out there, and it must be as comprehensive as possible. So rather put a lot of evidence than trying to keep the complaint to a minimum. You do have a word limit with the UDRP, but you can supplement that through annexures when you submit your complaint. Also, what they look at is the visual and verbal comparison in the domain name. So it's important to attach trademark certificates if you have, and any other forms of use, so that you can show how your mark is being used. The second element is whether the respondent has rights or a legitimate interest in respect of the domain name. So the obligation is on the complainant to make out a prima facie case that the respondent lacks rights or a legitimate interest in the domain name. The reason is that panelists have recognized that it's an impossible task to prove a negative when information rests primarily with the respondent. So once you've established that there's no rights or legitimate interests, the burden then shifts to the respondent to show that they indeed do have some sort of right in the particular domain name. So that's where non-use would come into it, passive holding, but that links to bad faith, and I'll explain that shortly, passing off as well. And you then need to look at and say, is the respondent using the domain name for a legitimate purpose? And in most cases, you'll see what will happen is the respondent or squatter will point the domain name to an affiliate site. It's got all these links, and probably the competitor's name is mentioned in there, or the client, the trademark owner's name. So clearly there you would say, they're not offering goods and services that are bona fide. So, it really depends on how they've used it. So kind of the second and third element go hand in hand. With the third element, there are numerous factors, and in the UDRP policy, it lists them there. So that's something that you can read up on. But some pointers that I would like to mention in this last element is that here it's important to show a pattern of conduct, as previously mentioned. So this is previous registrations or previous UDRP decisions against the owner, how it's being used, are there affiliate links, are the parties competitors, are they trying to disrupt the business? And in that, this is where the use element comes in, that it's been held in previous UDRP decisions that an inaction can constitute use. So by registering a domain name and not using it for a website, you're kind of blocking the trademark owner from associating their brand with that domain name. And a lot of squatters do that. So there is precedence to say that the inaction can constitute use. Then you need to see whether it causes confusion as to the source, sponsorship, affiliation, or endorsement, in that someone visiting the particular domain name or website would then be confused as to who the party is that really controls this particular website or domain name. So that's kind of those three elements. If you're successful in each of those elements, then the panelists would decide in your favor. Going into the practical side of it, there are some recent cases where trademark owners have been successful. So that's Michelin, France.online.top.xyz. Those are the new GTLDs. Facebook as well, Kellogg's, Virgin, Marlboro. So those are straightforward ones where they have been successful in a UDRP case. So they recovered those domain names. What I think is important to discuss is when things don't work out and look and say, why didn't they work out? So here we have on the right-hand side some failures where these domain names weren't recovered for a variety of reasons. I'll go through each one. But failing in a UDRP is quite a serious matter because it's very difficult to take action after that. You know, sometimes it precludes you from going through the court system, and there's sometimes no appeal process, so you're kind of stuck with that decision. So looking at the first one, I'll go through those because it's not a well-known mark, but in that particular case, the respondent had a legitimate right in the domain name and was using the domain name in connection with its business before the dispute. So the complainant was not able to prove bad faith, and it was kind of descriptive of its services, so they weren't successful in recovering that. In the second one, and this happens quite often, is when there is a town or a geographical place or indicator, and the person uses that as part of the domain name. So in this one, it was Genting. So they argued that there was a town. I can't remember where the town was, but it had the name in that. And that was the complainant failed in that particular case because they proved legitimate use. Then jumping to My Cadillac, I'm just jumping down to the bottom, is that this one was a case where Cadillac, you all know the well-known car manufacturer, failed to recover mycadillac.com. So in a case like this, it's very important to get your evidence and make sure that you have done a thorough investigation. What happened is, and I didn't know this until reading the complaint, was that the founder of the car company, Henry Leyland, had a family member that was the founder of Detroit in the U.S., and their surname ended in Cadillac. So as a result, there are a lot of places called Cadillac in the U.S. So the panelists, in looking at this UDRP case, said that especially the bad faith element, there was no pattern of conduct, there were no link to competitors, and there was nothing in the record to contradict the respondent's assertion that he registered the domain name because of its connection to the personal geographical name Cadillac, and not because of the complainant's mark. So in this particular case, the respondent asked for the panelists to make a ruling that this was reverse domain name hijacking, and the panelists said no, it wasn't. But in this particular case, they failed. When additional words are added to a domain name, like my in the front, it's very important that you deal with those words as well and the confusion that they cause. And sometimes people tend to, or attorneys tend to say, well, it's kind of a descriptive word, and so ignore that, just look at the main word. But my Cadillac, you know, anyone would assume that maybe it's personalized to the car, you want to customize your car, so look at that. Also, if the use, and say it's pointing to the city of Cadillac or the mountains in Cadillac, rather hold back on the UDRP complaint and wait until the use reflects some sort of infringement, then take an evidence grab or a screenshot, and then decide to take action. Don't just jump on anything that has the client's mark in, because it can backfire. Another one is Marlboro.party. Party is a new TLD. So in this particular case, it was argued that it was registered after a geographical area and it did not specifically target the complainant's tobacco business. Although the client had a series of trademarks, they said it didn't relate to one in which they had trademark rights. And I don't agree with that. I think maybe the lawyers used the wrong mark, but if you have marks filed in different classes, look for one class that is closer to the way the domain name was used. I know there are smoking laws around in different places which legislate how tobacco companies can advertise, but I know in the past, and when I was young, that cigarette companies used to have parties and events and sponsor that. So Marlboro.party, there's a good chance that someone that smokes a cigarette may be searching for some sort of sponsorship by the well-known tobacco company. So in that case, they weren't successful in gaining the recovery of that particular domain name. The Range Rover Chauffeur.com case is very interesting because unlike the two previous cases I've just mentioned, is that the respondent did not respond to the complaint. So the panelists took the argument into account and then took inferences as well. So they said that the domain name owner, the trademark owner was not in the business of operating a chauffeur service. So therefore, it was not confusingly similar, and they failed in the first argument, which is quite surprising. And then they said that the domain name owner was making bona fide use offering of goods and services, in that it was a chauffeur service that happened to use that particular car. Just to show you, which I disagree with the decision, maybe some of you don't, but if you look at that, that is the website. So if I go now to Range Rover Chauffeur, that's what I'm faced with. So I look at that. I may look at that and say, well, do you know what? Without reading into it, it could be that the company now is attempting to market its cars in a different way, so you can maybe drive around in it. If you like it, you could potentially buy it. Alternatively, it could happen that you take your Range Rover in for a service, and some companies offer you a courtesy car, and you use that courtesy car. So that does cause a bit of confusion. The panelists did refer to the disclaimer on the website, which I've circled towards the bottom right-hand corner. But as you can see, I didn't expand the image, but as you can see, it's something that you won't pick up on. It has a transparent background. It's very small, and that's a link to the Range Rover official website. And it says that it says here, we are an independent chauffeur service and not connected with Land Rover or Range Rover. Click here to visit Land Rover's own site. But that's something that you wouldn't really see in looking at that. Also, the logo, the way it's written, I would say that is confusing, but they weren't successful in recovering that particular domain name. So I apologize. There's some sort of feedback on this webinar. I'm not too sure if someone's microphone was is on, but I apologize for that. I can hear some noise in the background. So if you do have a microphone, if you can mute it, it shouldn't be coming through, but it is for some reason. Then looking at, I'm just going to jump ahead and then go back. Comparing the UDRP versus the URS, the UDRP is the default recovery procedure for new GTLDs. So there you need a common law mark and a registered mark. The URS, what that is, it's a new form of brand protection mechanism. And what it does do is it allows a trademark owner with a registered trademark, so it doesn't apply to common law marks, to have a domain name suspended for the duration of the registration period with the possibility of extending it by 1 year if the domain name is renewed. So what it is it is cheaper, it's quicker, and it takes down the website so because the domain name is suspended. The only problem is that if the domain name holder renews the domain name and it passes that period, then the domain name is activated again. And the hope is that potentially they will just leave the domain name, allow it to expire, and then you can snap it up afterwards. But the URS is really something I would only go for if you're struggling to take down a site, or time is of the essence and you need that to be taken down very quickly. So comparing them side by side, the filing fees are substantially higher, 1,500 for the UDRP at the highest cost and around about 500 for URS. The duration plus minus 30 days, it says 30 days, but it's normally longer because sometimes there are amendments that have to take place, but it can be 30 to 60 days. URS is 18 days, and the important thing is that the domain name is suspended under the URS, while the other one you can gain control. What is required for the URS? Not only do you need a registered trademark, but you need proof of use to show that you've in fact used that mark. So that's quite important. There is a word limit, so 2,500 words. I know many lawyers struggle to keep the number of words down. It can be quite difficult, but it is important, especially for the URS. For the UDRP, depending on the supplemental rules, every provider has different rules, but it's essentially not more than 15 pages, but you can go beyond that with annexures. With the UDRP, there's 1 to 3 member panel. If it's a 3-member panel, you pay an additional fee, and then 1 examiner under the URS. With the UDRP, you can appeal it to a court, depending what country you're in. Certain countries will not consider a UDRP decision. There's case law in certain countries saying that they're the court of final instance in domain name disputes. The URS allows you to appeal. There is an appeal panel within the URS procedure. You can also seek relief under UDRP. So what you can do is have the domain name suspended, have the website taken down, thereafter file a UDRP and get the domain name back or go via a court procedure. So now I'm just going to go back a bit. Going back is I just wanted to mention a few countries that have dispute resolution procedures, and it may be applicable to some of the attendees. It's also important to kind of understand them because everyone may one day be affected by it, especially the first one, the CNDRP. That's the Chinese Dispute Resolution Procedure. And in there is the possibility to argue your case in Chinese. For .cn complaints, that's the CCTLD for China. It says that the language should be Chinese. But in some cases, if you have communicated with the registrant in English, you can argue that they speak the language and understand it, and for speed and convenience, it should be heard in English. There is a limitation within the CNDRP, and that says that it only applies to domain names that are 2 years old. So when you register a domain, when a squatter registers a domain name, you have 2 years within which to use a CNDRP. After that, the local court procedures apply like traditional trademark infringement. So a lot of squatters are aware of this in China. So what they do is they lay low. They would register, for instance, say google.cn, and they would wait 2 years. After the 2 years, a nice little website will pop up saying, if you're the trademark owner, you can buy this domain name for $10,000, $15,000. Then what happens is the trademark owner gets irate, says, no, I'm going to sue you under the UDRP. They then realize that it doesn't apply, and they get a quote from a local Chinese lawyer, which can be very expensive, and then they say, well, it's just better just to buy the domain. And then the squatter is in a very strong position. So when you do an audit of your brand, and if you do need assistance, you can contact us. We do audits on trademark owners and how their trademarks are being used within the domain name space. You can identify these domains and then take appropriate action as early as possible. Then you get the AUDRP that applies to Australia. The com.au is the most popular extension. It's very similar to the UDRP, with the exception that the third element says registered and or used in bad faith. So it's not and as in the UDRP. Then South Africa has an ADR, and in the South African system, they talk about abusive registrations. It's very similar to the Nominet DRS procedure, where they talk about an abusive registration and the various factors that make it an abusive registration, very similar to bad faith. But the one thing that's unique, and this is why I've mentioned the South African Dispute Resolution Service, is that it has something called an offensive registration. So this is where the complainant cannot establish rights in the domain or in a mark, but the registration of which is contrary to the law, contrae bonos mores, or is likely to give offense to any class of persons. So you could be offended by a domain name under this particular provision within the ADR and apply to have the domain name cancelled. And the way that it works is once the domain name is cancelled, it cannot be re-registered or used ever again. So it's quite strange that is in there, but it is. I don't know of any decision yet that dealt with offensive registrations. Then looking at Nominet DRS, that's pretty straightforward. They do have a provision for mediation before it goes through to a decision, and then the fee is about £700. But if it's a default decision, if you want a summary decision as opposed to a full decision, you can get a refund. So that's about half of that. So that's quite affordable. Then you get a CDRP, which is for CA domain names. That's for Canada. And in this particular dispute resolution process, you need to have some sort of local presence. So if you're trying to enforce your rights, you either need a Canadian trademark or you need to be a Canadian company, and there's no requirement, no use requirement in bad faith. So that makes it slightly easier to recover. The same, funny enough, is for Australia as well. You do need to have a local presence because in order to register and maintain a com.au, you need either a local trademark or you need to be a local company. The NZ for New Zealand, they have a DRS procedure similar to Nominet and a hybrid of the UDRP, and they then talk about unfair registrations. So these are kind of countries, once you look at their various dispute resolution services, you see they're kind of similar, and most of them talk about bad faith, legitimate interests. So if your client has strong rights, normally the process is straightforward. But as I highlighted in some of those cases, it can go wrong if you don't do a thorough investigation into the matter. So having said that, that comes to the end of the webinar. I try to highlight the more important elements for lawyers and the practical aspects for brand owners, just because it can be overwhelming when you are dealing with domain name disputes. If you do have any questions, feel free to contact us. Our contact numbers are over there for the US, UK, and South Africa, or you can email us at brandprotection@lexsynergy.com. We work with a lot of lawyers, so we do a lot of drafting, ghostwriting as well, where we prepare the complaints on behalf of the law firms so that they can recover domain names for clients. And we do all the investigation work. There's a lot of work involved before filing a UDRP complaint, and I think that's where a lot of trademark owners sometimes fall short, is they think it's a straightforward process, simply filling out a form on a template and submitting it, but it's not. So it's important to get it right the first time, because you may not get a second chance. So if there are any questions, feel free to insert them into the chat box. If not, I would like to thank you for attending and hope that you found some of the discussion points useful. And like I said, if you have any offline questions, feel free to get in touch with me or with Marina. So once again, thank you, Marina. I don't know if there are any questions there.
No questions at this time.
Okay, great. So I've addressed all aspects, so that's perfect. Once again, thanks a lot, and we look forward to seeing you hopefully in our next webinar. Thanks a lot.